Good afternoon, everyone. Welcome to this month's Employee Benefits Compliance webinar. I am Jenny Badeau with Assurex Global, and thank you for joining me here today. Today, the experts from Benefit Comply will be educating us on a very hot topic, benefits during leave. And as we are getting started today, and as folks are still kind of joining us here, we would like to kick off by asking you all a polling question, or actually two polling questions, which you should see coming up on your screen here. We are curious about your benefits, priorities, and strategies for the year. So please take a moment and let us know your responses. You'll note for that first question, you just kind of pick the top one that applies. And for that second question, you can pick as many as apply to your company. And we would like to extend a special thank you to your local insurance benefits advisors and consultants who are partners of Assurex Global for making today's webinar possible. And we do welcome your questions today. If you have questions at any time during the presentation, please submit them using the Q&A function that you'll find towards the bottom of your screen. We do anticipate a lot of questions today, so I know our presenters will do their best to get to as many of them as they can. But if we aren't able to get to your question, please follow up with that benefits advisor who invited you here today. They'll be able to assist you further. And we do record our sessions, and a link to the recording, as well as a copy of the presentation slides, will be available early next week from the benefits advisor who invited you here today. And I will also drop a link to the presentation slides in our chat section here in just a couple of moments. And it looks like I still have a few poll responses kind of trickling in here. So I'm going to leave these polls up for just a moment. And as we collect those last responses, I'll kind of share a little bit of insight because we have asked these questions in the past. So last year on that first question around the top benefits priority, we found that managing costs to meet budget was the top response, probably not a surprising response. That's going to be a number one priority for many of you year over year. Last year, we found that focusing on compliance initiatives was kind of the second most popular response. Seeing similar results so far this year. And as far as that second question, kind of what strategies are being implemented, last year we had a lot of respondents telling us they weren't taking any specific action, but of those that were taking action, focusing on the wellness program was the most popular response. And we're seeing some consistencies here, although kind of a fluctuation in the percentages. But let me close these out and share these out with you so you can see how your peers responded. Give me just a moment. Okay, so I'll leave that up just so you can kind of get a picture of where the responses came in, but we do publish the results of these in a document we call a market check survey. So if you're interested in kind of exploring these more, be on the lookout for that to be published here in the next week or so. But without further ado, let's get into today's content. Joining us from the Benefit Comply team, we have David Flotten, Senior Consultant, along with Amanda Olim, Consultant. So David and Amanda, I will hand things over to you.
Great. Thanks, Jenny. All right, so welcome everybody. And yes, this is a very popular topic. So we are going to try and get through and provide as much information as we can. As Jenny said, please submit questions, but I'm almost positive we're not going to get through all of them, but we will do our best. We decided to approach this a little differently rather than just doing the kind of usual, here's what the FMLA requires and here's what this requires. What we decided to do is we put together a series of case studies to help illustrate some of the most common issues we run across. And, I don't think I'm kidding when I say like half of the questions we answer in a given day have to do with this topic. So we have lots to choose from. So hopefully you'll find something that seems familiar to you, or at least maybe seeing it in context rather than just as an abstract concept. Maybe some of these ideas will kind of click, make some sense. So Amanda and I will kind of be handing back and forth as we go here. But before we get into the case studies, thought we'd start with this, because this is kind of the way we think about and analyze when we get questions about what happens to benefits during leave of absence. This is kind of the three-step analysis that we go through. And you go through them in order, step by step. And if you get an answer to your question at one step, you stop. And if not, you keep going. And so those three steps that we go through are, first we ask, is the leave of absence legally protected? And a lot of times that means FMLA. And as we're going to see, though, that's not the only type of legally protected leave that is out there. If there is no law, it's not a legally protected leave, or the law in question doesn't address benefits, then we have to go on to the second step, which is, do the plan documents address eligibility during leave? Unfortunately, a lot of plan documents are silent or ambiguous when it comes to that. But if you happen to have a plan document that very clearly addresses what happens to the benefits during the leave, then you have to do what that plan document says. That's what's going to control. But if that doesn't answer the question, we go on to the third step, which is, what is the employer's policy regarding benefits during leave? If we don't get an answer from the law and we don't get an answer from the documents, the answer to the question of what happens to the benefits during leave is, I don't know, what does your leave policy say? And as we're going to see, that's going to become kind of a big deal. If you don't have a leave policy that addresses it, it sometimes becomes very difficult to figure out what you should be doing or how you should be proceeding. So we'll talk about that and what those leave policies should ideally look like. But we'll use this as our framework as we're going through these examples, just to kind of, so you can see how we use it, how we think about it, and how it plays out in various somewhat common scenarios. Okay. So with that, I'm going to hand it over to Amanda for our first case study.
All right. Case study number 1, we are going to be looking at Marjorie's situation. So we have Marjorie, who works for Basic Co. Basic Co. employs 175 employees at a single location in Oklahoma. Marjorie has been employed by Basic Co. for 4 years, and during that time, she's worked 40 hours per week. And there have been no major deviations in her work schedule over the last year. Marjorie is pregnant and she has requested 12 weeks of leave following the birth of her child. At the time that her leave begins, she's enrolled in medical, dental, vision, life, and disability coverage. And Basic Co's FML policy states that they will cover the employee's share of the premium while the employee is on leave, and then the employee will be expected to pay it back, and Basic Co will recover that premium when they return to work. Okay, so as David said, we are going to use our framework to analyze this. So again, the first question that we're going to ask is the leave of absence legally protected? So in order to answer that question, we need to, in this case, we're specifically going to start with FMLA, right? So we need to determine first if the employer is subject to FMLA. So based on the fact scenario, we know that the employer is subject to FMLA because we were told that there are more than 50 employees. Once we know that, we need to discover whether or not the specific employee is going to be eligible for FMLA leave. And there's a few things that we need to know to make that determination. So first of all, Marjorie has been employed for at least a year. In that last year, we know that she's worked at least 1,250 hours in the last month because she had 40 hours a week as her, typical employment. We were told there were no deviations from that in the last year. And then finally, and we actually have this in the is the employee eligible for FMLA section. I think sometimes there is kind of a misconception, but when we are asking whether or not a leave is protected, we ask whether the employee works at a location that has at least 50 employees within a 75-mile radius, because it is possible that the employer in general is covered by FMLA, but the employee might not be eligible if they're working at a location where that isn't true. We know that that is true in this case because we were told there was one single location that had that many employees in Oklahoma. All right, so now we know the employer is covered, the employee is in general eligible. So we move on to, is the reason for leave qualified as FMLA leave? In this case, it definitely is. Birth of a child is a reason for a qualified FMLA leave. And then finally, the question that we ask is, does this employee have FMLA time available? Again, we were told in the fact scenario that she didn't have any major deviations from her work schedule in the last year, so she hasn't taken any FMLA in that last year. So in this case, Marjorie's leave is an FMLA leave. And David, I believe you'll want to make a comment about calling it.
You're gonna talk about my
right?
pet peeve?
Yeah.
Yeah. It's a little nitpicky, but it actually is important. So when we talk about somebody being on FMLA leave, or we hear somebody say this employee is on FMLA leave, this is what we mean. We mean that these 4 questions, the answer is yes. The employer is covered by it, the employee is eligible, the reason for the leave qualifies, and the employee has FMLA time available. Unfortunately, a lot of employers, brokers, what have you, will kind of use the phrase FMLA as a kind of a generic term to mean any sort of family leave or medical leave. And that can get you the wrong answer. I had this happen just the other day where I was answering a benefits question during leave. They started out by saying this employee's on FMLA. We went back and forth like 5 or 6 times before finally the employer said, oh, we have less than 50 employees. Does FMLA even apply to us? Shame on me for not clarifying. So do you mean literally FMLA leave, or are you using that term loosely? But if you're talking to your employment law attorney or HR advisor and you just say FMLA and they don't think to question if you mean that literally or not, you are going to get the wrong answer, because the answers are different depending on if it's FMLA or not. So please try not to use the term FMLA leave if it's not really actually truly FMLA. Call it a medical leave, call it a maternity leave, whatever you want to call it, but try to save the phrase FMLA for actual FMLA leave.
Exactly. And to that point, FMLA has some major implications, right? So going back to Marjorie, we've determined that her leave is an FMLA leave, and we can call it that here. So in that case, Marjorie is going to be eligible for 12 weeks of protected leave, meaning her job is protected. It also means that during her leave, she is going to be required to be able to maintain her health coverage as if she was actively working. For these purposes, when we say health coverage, we don't just mean the major medical. This is also going to apply to dental and vision, really any of your group health plans, right? FMLA does not actually provide protection for life or disability plans, but it is the case that a lot of times employers are going to want to just kind of have one policy across the board that'll apply to all of their plans. In that case, sometimes they will be protected, but in that case, as we can't answer the question by using that first bucket, the leave is not legally protected, we have to move on to the second to answer that question. And we have to look at the plan documents, which is step 2. And that's where you would see whether or not the life and disability would be protected. So during her leave, again, the FMLA lets her continue her benefits as if she was actively employed, which means she's still going to be required to pay the premiums at the same rate. So if you have a situation where someone's leave is paid, what you're going to do is just continue to deduct their premiums as normal. This way, that employee is able to still enjoy the pre-tax benefits of having the premiums deducted from their paycheck. Things get a little bit more complicated, right, if the leave is unpaid. And FMLA generally gives us 3 different options. There is prepay, there's pay-as-you-go, and there is catch-up payments. So prepay, just a little note about prepay. You can offer prepay as an option for an FMLA leave, but you cannot require an employee to use the prepay option for an FMLA leave. So you can't say, hey, employee, you don't get to continue your coverage if you don't pay all of the premiums before you go out on leave, but you can give that to them as an option. When you do that, they can actually prepay for their coverage on a pre-tax basis. There is, however, one caveat to that. If the leave is going to extend into the next plan year, they cannot prepay on a pre-tax basis for that coverage that is going to be in the next plan year. So if they were going to prepay for coverage in the next plan year, they'd have to do that post-tax. Pay as you go, obviously, if the leave is not paid, there isn't going to be a paycheck to deduct the premiums from. So in that case, you have to think about how you're going to accept the payment, whether it's check or credit card. We'll talk a little bit more about that later on. And then finally, catch-up payments. And in this case, we were told that that is what Marjorie's employer utilized. So Marjorie would be able to not pay her premiums while she was out, and then she would be able to pay them back when she got back. You can actually also do catch-up payments on a pre-tax basis. And so yeah, deduct it from the paycheck like you normally would. And unlike the prepay option, even if you're into multiple plan years, so if she comes back and she wants to pay on a pre-tax basis for her premium that was in the prior calendar year, you actually can do that. So it's a little bit different than the prepay option. All right, to finish out Marjorie here, we have a few questions. So first, how quickly can Basic Co deduct catch-up payments from Marjorie's check when she returns to work? FMLA doesn't actually provide any rules about this. I think employees are obviously not going to want to have to pay it all at once because that could be a pretty large burden on someone, and a pretty big shock to the system to have their paycheck deducted by that much. That said, there isn't really anything that says, hey, employer, you can't do that. I would just say if you do want to have them pay it all back at once, maybe put that in a policy in some kind of communication, let them know before they go out on leave. Because again, just from an employee's relation perspective, that's probably not going to go over that well. Typically, I think we're just seeing catch-up payments where employers kind of just double up on the premium until it's paid back. Second question, if Marjorie's FMLA leave crosses the cafeteria plan year, can Basic Co deduct the payments pre-tax? Actually, I already answered this. And so the answer is yes, right? You can still do that. It's going to be different if it's a prepay option, but for the catch-up option, you can pay those on a pre-tax basis. And then finally, what happens to the premium payments if Marjorie does not return to work at the end of her FMLA leave? So the employer is still, in general, going to have a right to collect those premiums. The problem is effectively enforcing those rights. So, in theory, they could sue the employee for that amount to try to get it back from them. How often is an employer going to want to do that, especially for amounts that might not end up being that much? And then even if you do that, how often are you going to want to go through with the whole action and actually see it to its end is another question. But essentially the point here is just kind of, this is a lot of times why employers don't really like to use the catch-up option. And you aren't required to. You can require them to pay as they go if you don't want to use this option. But yeah, that's part of the reason why a lot of employers choose not to use the catch-up option.
Which is going to lead us into our second case study. But before we leave this, we've actually got a lot of questions about kind of employees working in remote locations, whether it's a small satellite office or they're remote workers, or maybe they don't have a fixed work location, like people who work construction or going from site to site. So a couple of comments. First of all, if we're talking about a satellite office, you actually have an office out there, but it's got fewer than 50 people and it's more than 75 miles away. The question is, are you saying those people are not eligible for FMLA leave? That is exactly what we're saying. You can grant the leave, but it's not FMLA. Okay. So that's what we're talking is a true satellite office, less than 50 people. No, those people are not eligible for FMLA leave. Remote workers who work from home, as well as people who don't have any sort of fixed work location. First of all, an employee's home is not a work location. What you have to do is you have to basically assign them back to whatever office they report to, and that's where they're counted. And then the same is going to be true for those people without a fixed location. They get put back in the location where they report to, where they get directions, and they're counted there, which can mean that you've got, one person in Alaska working from home, but because they get put back in the New York office, they are in fact FMLA eligible. Okay.
Great questions.
All right, so let's look at what happens then when we don't do catch up and we do pay as you go, which is going to be Jerome here. So Jerome works for a company called Sting. Sting is covered by FMLA and Jerome is eligible for FMLA. In contrast to our previous case study, their policy does say premiums are going to be paid. They actually require the premiums be paid on the same biweekly payroll schedule. And they do say we will cancel the coverage if it's not paid in a timely manner. So Jerome needs 12 weeks of leave due to a back surgery starting January 13th, 2025. He has medical and STD coverage at the start of the leave. He files an STD claim, which is approved, and it includes a premium waiver, which means no premiums are due while the claim is being paid. So the only premiums we have to worry about here are the medical ones. And initially, Jerome keeps up with his premium payments, and he pays on time. But 6 weeks into his leave, he misses the payment that should be due on February 21st. Okay. So, same starting point as before. Is the leave of absence legally protected? Yes, the facts tell us the employer is big enough, the employee is eligible, this is an FMLA qualifying reason. So yes, the FMLA is going to apply. Much as with Marjorie, the way he pays his share of the premiums, one, if he was getting paid through payroll, we would do a payroll deduction. Now, he is sort of getting paid here in the sense that he's getting short-term disability benefits, but of course, those are being paid by the carrier, so the employer has no real way to deduct, if anything, from that. So as a practical matter, this is effectively an unpaid leave, and we have the same three options as before: prepay, pay-as-you-go, catch-up. In this case, though, the employer said, we're going to do pay-as-you-go, and you need to write us a check or give us a credit card number, what have you, each biweekly pay period. And by the way, you can set that schedule. You don't have to do it on the same payroll cycle. You can do it once a month. You can decide what the due dates are. And that due date does become important for what's happened here. So the question is, so you do pay as you go. What happens when the employee misses a premium payment, as Jerome did here on the 21st? And the FMLA has rules around that. And it does say you can cancel if they fail to pay the premium, but there are two hoops you have to jump through first. The first one is the employee gets a 30-day grace period. So it's not actually, the payment isn't actually late until 30 days after the due date. So in this case, where the due date was February 21st, Jerome actually can pay anytime up to March 23rd, and it's not going to be considered late. The second hoop is that before you actually cancel the coverage for non-payment, at least 15 days ahead of that, you have to send out a written warning that says we're about to cancel your coverage for non-payment, and if you don't pay by whatever the applicable date is, we will cancel the coverage back to the last date that you paid. Okay? So in this case, if they want to, if Sting wants to be able to cancel coverage right on March 23rd, then no later than March 8th, they need to send out this warning letter. And that is no later. They can send it out earlier. If they want to send it out on February 22nd, the day after the payment was due, they can do that. It's just that if you don't give 15 days warning, you can't cancel at the end of the grace period. You got to wait till the end of the 15-day warning period. Okay. But if you do those things, jump through those hoops, and the employee doesn't pay, now you can, in fact, cancel the coverage retroactively back to the last day premium was paid. So in this case, where Jerome's payments are due each biweekly pay period, that would be back to February 8th, which would be the day after the last payroll period ended. But the FMLA also says if you do that, if you end up canceling the coverage for non-payment, when Jerome returns to work, they have to reinstate his coverage just as it was before, notwithstanding he's going to have a gap in there. But they can't make him wait till open enrollment just because it got canceled for no non-payment. It gets reinstated when he returns. Okay. So, a couple of questions. The first is really just kind of a rhetorical or something to think about question. So, in this example, the grace period for the late payment ends March 23rd, but if you count out the weeks, Jerome's FMLA payment is actually going to end April 6th. You got to ask the question, is it worth going through the rigmarole of getting to the 23rd, canceling the coverage, 2 weeks later he comes back, now I got to reinstate it? I mean, it may be worth it, but you have to think about that. Here's the other problem. What if coverage runs on a calendar month, as a lot of our benefit plans do? Coverage normally only starts and stops on the first and the last day of the month. which raises some problems here, particularly with this biweekly schedule they've set up. Can they actually cancel his coverage as of February 8th? I mean, legally, that's when they're allowed to do it. But if the plan coverage runs on a calendar month by calendar month basis, they may not be able to go any further back than March 1st. They clearly can't go back to February 1st because he's paid for those. So, this biweekly schedule may not make a lot of sense if your benefits are running on a calendar month basis. What about on the other side? What if they do cancel his coverage for non-payment? He returns to work on April 7th. That's the middle of the month. We have to reinstate his coverage. When does it get reinstated? Well, again, we can't wait until May 1st. The FMLA says he gets his coverage back right away. So usually we can strong arm the insurance company to let the coverage start mid-month in this situation by saying this is FMLA, it has to. If for whatever reason they balk at it, they might actually have to reinstate the coverage early as of April 1st in order to satisfy their obligations under FMLA. Okay.
So we did have one question I thought might be good to bring up here. When you cancel coverage specific to someone not paying their premiums, you do it, legally with the grace periods intact and everything. That is not a COBRA qualifying event, right?
That is correct.
That is just canceling the coverage. COBRA is only, you only have the requirement to offer COBRA when someone experiences a COBRA qualifying event, and not paying premiums is not a COBRA qualifying.
All right, let's look at number 3, which is Zaya. So Zaya also works for the same company, Sting. She is eligible for FMLA leave. She requests 12 weeks of leave to care for her sick mother in Bangladesh. And she has medical and dental coverage at the start of the leave. However, she says, because I'm going back home, I don't need this coverage. And so she actually asks to drop her medical and dental coverage for the duration of her FMLA leave. And so that's the question is, can she do that? Again, we start with our analysis. Is the leave of absence legally protected? Yes, this is FMLA. And that becomes important because there actually is an FMLA rule that says not only can the employee keep their health coverage during the leave, they also have the right to not keep it. They have the right to discontinue it. And so, in fact, they do need to honor Zaya's request to say, I don't want this coverage, and they would shut the medical and dental coverage off during the leave. But much like where if we cancel coverage for non-payment, if we cancel the coverage because the employee requests it, when she comes back from FMLA leave, we do have to reinstate it. So again, she'll have a gap in coverage, but we can't make her wait until open enrollment. She gets the coverage back as soon as she comes back within the 12 weeks. She gets it reinstated as soon as she returns to work. A lot of people aren't aware of this. We don't actually have to advertise it, which is curious. But nevertheless, just be aware, if an employee says, I don't want to continue my health coverage, you do have to let them drop it. A lot of people ask too, can they change their mind halfway through? Can they start by doing it and then go, a month into it, this is too expensive, I want to drop it? I think the answer is yes. And there's nothing in the rules that says they can't. It just says they get to discontinue it. Similar question, what if coverage runs on a calendar month basis? Presumably, odds are Zaya's FMLA is going to start and stop in the middle of the month. Because this is FMLA leave, I don't think we have a choice. I don't think they don't have a choice. She gets to stop her coverage when her FMLA leave begins. She gets it back when the FMLA leave ends and she comes back to work. So you're just going to have to make clear with the carrier why this is FMLA leave, and that's why it is stopping and starting in the middle of the month. All right, let's look at one more before I hand it back over to Amanda. We're going to look at Dwayne. Dwayne also works for Sting, but he works specifically at their Colorado location, but he's a newer employee and he's only been employed for 8 months. He is having a baby, and so he requests 12 weeks of leave for the birth of his child. And he has medical, dental, and vision coverage at the start of this proposed leave. Now, start as always with, is this leave legally protected? Well, in terms of FMLA, which is what we've been focused on up to now, the answer is no. He's not been employed long enough to be eligible for FMLA leave. However, those of you who have locations in Colorado may recognize, well, we have a state law issue here. Colorado is one of the states that has a paid family leave law called Family, which does in fact grant paid time off, paid through a state program, but importantly, it gives the time off. And basically all employees are eligible for that, regardless of how big the company is, regardless of whether they're full-time or part-time, how long they've been employed. If they're working in Colorado, they're going to be eligible to take family leave for reasons that are basically mirror the FMLA, but in some cases are a little broader. The law comes with job protection if you've been employed 6 months, which Dwayne has in this case. But more importantly, for our purposes, there is also a provision that healthcare benefits have to be maintained during periods of family leave. Now, while the Colorado regs don't get into the detail as the FMLA, presumably healthcare benefits would include medical, dental, and vision. No reason to think it wouldn't. They can still require Dwayne pay his share of the premiums, and they give a variety of options for how to pay those premiums. They're a little more less defined, a little more vague. There's this kind of catch-all, any other legal means that they have. But so that raises some questions. For example, could you require a prepayment of premiums here? I mean, it doesn't say you can't, but is that any other legal means or not? It's not totally clear. Can we even cancel the coverage for non-payment of premiums during this family leave? Again, it doesn't say so explicitly, but it seems reasonable that if the employee doesn't pay, they don't get to keep the coverage. Okay. So the point being that even if you've got an employee, think about those remote workers we were talking about earlier who may not be eligible for FMLA leave, you do have to be aware of the law in the state where they are working. Because there are currently about 15 states with some form of paid family or medical leave, and more are coming. Some of those laws provide benefit protection, but some of them don't. Even in those states that don't have paid family leave, there's plenty of states that have unpaid family leave laws. Those laws almost always provide job protection. That's kind of the point. But they may or may not provide any benefit protection. Okay? Now, before I get the question, so which states are they? We can't go over all 50. You have to find yourself a resource that you can rely on that's going to help you understand in which states where you have employees, are there these additional leave laws that we have to think about, okay? And that's kind of the point. Legally protected here does not just mean FMLA. It can also mean the state leave laws. Somebody asked a question earlier about what about the ADA? We don't have a specific ADA example because the ADA isn't a leave law per se. However, it is true that a leave of absence might be considered a reasonable accommodation under the ADA. And if it is, then it would be legally protected. Now, as it turns out, the ADA has no benefit protections in it. So we very quickly drop into steps 2 and 3. But again, don't limit yourself to just thinking about strictly federal FMLA. Okay. Ready, Amanda?
Yes. All right. Case study number 5, we have Alicia. All right, so Alicia works for MAPA Inc., a 40-employee company based in Alabama. She requests 3 months of medical leave for cancer treatment. Unfortunately, the treatment goes slower than expected, so she requests an additional 3 months of leave about halfway through her original leave, so about a month and a half in. At the beginning of her leave, she only has medical coverage. MAPA's medical plan documents defer to the employer to determine eligibility. And MAPA has a medical leave policy that provides for up to 3 months of medical leave, during which benefits are allowed to continue. The policy also allows for extensions, but states that benefits are going to be terminated during any extended period of leave beyond that initial 3 months. So we start with step 1 again. Is this leave legally protected? So in this case, MAPA is too small. They don't have at least 50 employees to be subject to FMLA. And in addition, Alabama is one of the states that don't have any state leave laws. So in this case, the leave is not legally protected. That means that we are going to get to step 2. So the question is, do the plan documents address eligibility during leave? Well, we were told in the fact scenario that MAPPA's plan documents actually defer to the employer to determine eligibility. So in this case, the answer to step 2 is no, meaning we are getting here to step 3. So finally, what is the employer's policy regarding benefits during leave? We were told that MAPPA allows benefits to continue only for the first 3 months of Alicia's leave. And then for the period of extended leave, Alicia's medical coverage should be canceled and she's offered COBRA. So they have a policy in this case, and it says, okay, you get to have job protection for this amount of time, and only for the first 3 months do you get to have medical coverage protection. After that, you're no longer eligible. So it's important in that case to follow the policy, since it's the only thing we have, and offer the individual COBRA. So it's a good thing in this case, right, that MAPPA had that policy, because if they didn't, we wouldn't really know what to say as far as whether or not Alicia would still be eligible for coverage. We just wanted to provide you here with kind of like a checklist. If you don't have an FMLA policy, hopefully we have shown you why it may be important to have one. And if you're going to draft one, these are great things to include. So first of all, it should definitely cover how long benefits can be maintained before coverage is going to be canceled and COBRA should be offered. It should cover how much the employee is going to be required to pay in order to maintain that coverage during leave, and also when those payments should be made. So whether or not you're going to use the prepay, pay-as-you-go, or catch-up options, and ideally the due dates also. And again, in this case, it's a non-FMLA leave, so you could, in theory, require prepay if you wanted to. You should include in there, ideally, the acceptable forms of payment. So whether you're going to accept check or ACH or credit card, if you're gonna think about canceling coverage for non-payment, ideally that should be in the policy. And then in addition, if that is the case, are you going to reinstate that coverage when the person comes back from leave?
And maybe just point out too, we're using the term policy loosely here. We don't necessarily mean that all of these things have to be in the employee handbook. You know, some of the details, like what form of payment will you accept? Maybe that's just a standard operating procedure for HR's purpose, or maybe these things just get addressed in, you know, if you give a leave of absence notice at the start of the leave, that's maybe where some of this stuff is addressed. The point is that you got to think about all these things, because the law isn't going to tell you how to do it. You have to decide for yourself, which is good and bad. You have flexibility, but it also means there's no cut and dry answer. You have to come up with it on your own.
Because if you email us and say, what do we do? And you don't have a policy, we might say to you, time to draft one.
Yep. And ideally, you do this ahead of time. Don't, I mean, you want to really try to avoid doing this on the fly when it comes up and we go, now what? But if there isn't one, that's kind of what choice do you have? It's time to put one together and to address all these things.
It's always better to have something to refer back to say that's why we decided to make this decision, so that there isn't any room for anybody to say it's because of their specific medical diagnosis or the reason that they were requesting leave, or potentially their race, sex, religion, age, something like that, right? So, hey, we have a slight variation here on our Alicia case study. So 5.1 here, we are sticking with Alicia, same employer, everything, but we are adding the fact that she now has voluntary life insurance coverage. So the life insurance contract in this case says that coverage can continue for a period of 30 days of approved medical leave. So this is important, right? That's different than what we were told about the medical policy, but we're going to go through these same steps. So step 1, is the leave of absence legally protected for the life insurance, right? No, it isn't. So then we go to step 2. In this case, do the plan documents address eligibility during leave? So for medical, like we talked about, it wasn't in the plan document, so we moved on to the employer's policy. For the life insurance, we actually do have some eligibility language here. And that is specifically that she is only going to be able to continue that life insurance for a period of 30 days. And again, that's different than what their policy for medical coverage was, which was 3 months. So in this case, you have to make sure that you check all of the plan documents, including any wrap documents or stop loss contracts, right? Because it is possible, for example, that maybe the underlying benefit doesn't say anything, but you have a wrap document that addresses eligibility. You just need to be aware of all of the eligibility language that's out there. If MAPA in this case had just assumed that the life insurance was subject to the same policy that they use for their medical plan, they may have continued deducting life insurance premiums. So God forbid in that scenario, they're doing that. Turns out that the carrier comes back and says, well, that policy had to terminate after 30 days. That's what we had in the plan document. We're not going to pay out on that benefit if there actually was a claim for it. And this has happened. Like, this is one of those things that we actually see. And then you have a grieving family being told that policy isn't in place and there isn't a benefit to collect, which also puts the employer in kind of hot water because they, from an ERISA standpoint, they've been taking those premiums, right? In that case, the family may have a pretty good claim, and a lot of times you'll see these kinds of cases being settled, right? For some kind of a payment. So make sure we are checking all of our documents is the main point there.
All right, let's move on. So case study number 6 is Tariq. And this is actually, several of you have asked this question. What happens if somebody is on FMLA leave and then they need more time? What happens then? Well, that's what this is for. That's what this study is here for. So Tariq works for a company called Generoso at their Florida location. They are subject to FMLA, and he is FMLA eligible. They do require premiums be paid during the leave, or coverage will be canceled for non-payment. Their medical plan documents say coverage continues during FMLA leave, but don't say anything about what happens during non-FMLA leave, which is so helpful because I know what happens during FMLA leave. It's the other one I care about. But this is very common, where the plan documents don't say anything. They also have a non-FMLA medical leave policies, very generous, as the name suggests. They allow for up to 6 months of non-FMLA leave, but only you let them keep the benefits for the first 3. So Tariq needs heart bypass surgery, so he asks for FMLA leave. At the end of the 12 weeks of FMLA leave, Tariq requests an additional 4 months of leave to further recover from his surgery, which Generoso grants. Okay. So is the leave legally protected? Well, it's a split answer, right? For the first 12 weeks, the answer is yes. This is FMLA leave. The FMLA rules apply. Turns out Florida has no state leave laws, so we don't have to worry about that. But then once he exhausts the 12 weeks of FMLA, the answer changes to no. They've granted him another 4 months of leave, but that leave is not FMLA. Now somebody's saying, could this be ADA leave? Maybe, but actually the ADA doesn't usually require 4 months of leave. This is almost certainly just purely employer protected leave or employer granted leave. So no, there is no FMLA, there's no protection in those 4 months. So we have to move on to step 2. Do the plan documents address eligibility? Unfortunately, like I said, it's fairly common. They're silent. They don't say what happens during the leave. And so we end up back at step 3. What is the employer's policy regarding benefits during the leave? Now again, fortunately, Generoso has a clear policy here that says we will let you keep the coverage for the first 3 months of non-FMLA leave, but at that point it will be canceled subject to COBRA. Essentially what this is, if you look at this is really just a combination of case study number 2, which was FMLA leave, and case study number 5 that Amanda just went over, which was non-FMLA leave. Now in Amanda's case, it was non-FMLA leave because the employer was too small. In this case, it's non-FMLA leave because the employee has exhausted their FMLA leave. It might be non-FMLA leave because the employee isn't eligible yet for FMLA leave. But in the end, it doesn't matter because we're going to end up in the same place. We're going to check the plan documents, probably silent, and then we're going to land back at the employer's own leave policy. which is again why we kind of harp on it and emphasize why it is really important to have that policy, because in a lot of cases like this, it is going to be that your policy that dictates the outcome. Now, let's look at the reverse situation. So we had somebody who was FMLA eligible, exhausts the time, and needs more time. We're going to kind of flip that around a little bit when we talk about Jenna here. So Jenna works 40 hours per week for Stand Up Bank in one of their Nashville, Tennessee branches. Stand Up is large enough to be covered by FMLA, but Jenna has only been employed by them for 11 months. Jenna requests 8 weeks of leave to recover from knee surgery, which is granted under Stand Up's non-FMLA medical leave policy. And under that policy, employees can continue their benefits for 60 days, after which the coverage is terminated, subject to COBRA if it's applicable. And Jenna has medical coverage only at the start of her leave. However, during that non-FMLA leave, 3 weeks into it, she actually reaches her 1-year anniversary date, which we're going to see is important. Unfortunately, Jenna's recovery doesn't go well. We have a lot of people having trouble with their recoveries here. And so she asked for an additional 6 weeks of leave in addition to the 8 she originally requested. So a total of 14 weeks of leave. So now when we ask the question, is the leave of absence legally protected, we kind of get a split answer. But at the start anyway, the answer is no. She's not FMLA eligible because she's only been employed 11 months. Turns out Tennessee has a family leave law, but not a medical leave law. So she has no state protections. So initially, no, this is not a legally protected leave. It's just a leave under Stand Up's non-FMLA leave policy. However, once Jenna gets to her 1-year anniversary, what happens? Well, now she has 12 months of service. Now we're told she's a 40-hour-a-week employee, so she presumably has the 1,250 hours. We're told there are several branch locations in Nashville, so presumably she works at a location where there's 50 people in a 75-mile radius. So suddenly in the middle of this non-FMLA leave, Jenna becomes FMLA eligible. And what was a non-FMLA leave suddenly now is FMLA. The FMLA rights spring up when she reaches her anniversary date. Now that means when she gets to that anniversary date, she now has 12 weeks of FMLA leave coming. And that 3 weeks she already took has no effect on that because by definition, it was not FMLA leave. She has a full batch of 12 weeks of FMLA. That's why she's able to take the full 14 weeks because she's counting from when she became eligible. She had 12 weeks of leave she could use. But from our perspective, talking about benefits, that also means the FMLA benefit protections kick in on our anniversary date as well. And if you remember, we said Stand Up's policy says the coverage is canceled after 60 days. Well, the problem is that by the time we get to that 60 days, she's actually in her FMLA leave. And so now they can't cancel the coverage. She does in fact get to continue it without having to go through COBRA. She just continues to pay her share of the premiums. So you do have to be aware of this when you've got people who are close to that anniversary date, that if you're going to grant a non-FMLA leave, in a lot of cases you are, it's kind of awkward to say, I know you're 2 weeks short of your 1-year anniversary, so I deny your leave. I mean, that doesn't really go over very well. But you do have to recognize that does mean if they reach that 1-year anniversary, and that's usually what's going to cause the threshold to change, that the FMLA can and does spring up at that point. And at that point, you have to follow the FMLA benefit protection rules once again, even though you didn't have to at the start. Now, interestingly, if Stand Up had a less generous leave policy, if they said, we'll grant a leave, but we immediately cancel your coverage in COBRA, now the FMLA leave would still spring up, but at that point, she would have no coverage because it would have been canceled earlier. And she doesn't get reinstated. She gets what she had at the start of the FMLA leave, which in this less generous scenario would be nothing, or COBRA if she elected it. Okay. So something else to think about when you're writing your non-FMLA leave policies. All right. Lastly, Florence.
Case study number 8, Florence here. So Florence works for Lumberjack Chainsaws Inc. or LJC. LJC is large enough to be covered by FMLA, and Florence is FMLA eligible. LJC also has a non-FMLA medical leave policy that allows for up to 12 weeks of leave, during which benefits are continued. LJC's plan documents all either defer to the employer or are silent when it comes to benefits during periods of non-FMLA leave. Florence suffers a significant work-related injury, which takes her off work for 12 months. Chainsaw company, work-related injury. Oof. Okay. So step one, we're still starting with here. So is the leave legally protected? So yes, for the first 12 weeks, we have FMLA leave, right? We were told that the employer is subject, the employees worked there long enough. So for those first 12 weeks, we're just going to follow the normal FMLA benefit rules. But we were also told that she's going to be gone for a lot longer than that, right? And FMLA only gives us 12 weeks of protected leave. So the remaining time is not legally protected. We've kind of touched on this here already. Work comp does not actually provide for job protected leave. We haven't really talked about work comp, but David's brought up the ADA, right? We've had a few questions cycle in on both of those. So you know, work comp and the ADA may require you to provide an accommodation, which is a leave, but that doesn't mean that that leave protects the right to continue benefits. The same goes for work comp in this scenario. A work comp leave doesn't provide for job protected leave. So we're still in the area of this not being a protected leave. There are laws under the work comp where you can't discriminate or retaliate against someone with a work-related illness or injury, or treat someone worse than an employee with a non-work-related illness or injury, which is another reason why having a non-FMLA leave policy is so important, so that you can say definitively, this is how we treat a non-FMLA leave, right? So in this case, Florence benefits should be terminated and COBRA should be offered 12 weeks after the end of her FMLA leave, right? Because they had that 12-week benefit eligibility policy. And that's the case even though the employer decides to extend her leave for an additional 6 months. She only gets to continue that coverage for an additional 12 weeks, as is written in their policy. All right.
Yeah, and I think that this is a common misconception, that I think a lot of people are under the impression that if it's work comp, basically I can't touch them. And that is not true. Very often you are going to grant longer leaves than you would normally. This was up to a year, just because we want to kind of maintain control over the work comp claim. But they don't get treated any better, particularly when it comes to benefits, than any other employee out on medical leave. So that is ultimately the message here: is treat work comp the same as you would any other medical leave. It starts as FMLA, you designate it as FMLA leave, you follow the FMLA rules. After that, you follow your non-work or your non-FMLA medical leave policy, and you cut off the benefits the same time as you would anyone else. And to Amanda's point too, this is why it is so helpful to have that policy in advance. This is not the situation where you want to have to be drafting a policy, because you have nothing to point to say we're treating them the same as everyone else, and you do run the risk of that kind of discrimination, or retaliation type claim. So definitely try to get a policy written before you run into an extended work comp claim like this, and have nothing to point to say this is what we normally do. All right, we do have a ton of questions, and I know Jenny has a poll she wants to do. So I'm just trying to, just glancing through here to see if there are any kind of common threads that we can talk about.
There was one question about back when we were talking about how to pay for coverage during leave. There was a question about plan year versus tax year, right? So in general, when you make a pre-tax election under a Section 125 plan, it's not necessarily tied to the calendar year. We're talking about the plan year. And so when I made the statement, you can't go back into the last year, or sorry, you can't go forward into the next year when you're prepaying. What I meant is plan year. Reason being for that, because you haven't made that election yet. So it's not necessarily calendar year, it's plan year.
We haven't really talked about dependents in any of our examples, so that somebody asked the question, does the FMLA allow them to keep their dependents on the coverage during the leave, and how much do they pay? And the answer is yes, it does. It protects whatever coverage they had in effect before the start of the leave, including dependent coverage, and they would only pay what they would pay as an active employee for that dependent coverage. So there's no difference there. Another question, this kind of goes back to what we were talking about remote employees, but when we start talking about state leave laws, which state's law apply? Is it the law of the state where the company is located? Is it the law of the state where the employee lives? And no, it's the law of the state where the employee works that controls. It's where the physical work is done. So a remote employee in Washington who works from home for a Kansas company is subject to Washington state paid family leave law because that is where they are working. That's what's going to count. I think we maybe have time for one more. So here, related to the payment too, is it permissible for the employer to pay the premiums on behalf of the employee while they are on FMLA and not require repayment? So that's true. We didn't list that as an option, which is the employer just covers the premiums. And legally, that's fine. There's nothing in the FMLA that says you can't do that. I would start putting on my HR hat, start to get concerned about consistency and discrimination. Are you saying you're going to do that for everybody? Probably not. In which case, how are you going to distinguish and pick and choose who you're going to cover the premiums for and who you're not? Because that can open up a whole can of worms when it starts looking like, gee, you're paying for all the men and not the women, or you're paying for the people who, haven't given you any trouble and not paying for the people who have filed complaints against you, what have you. So yeah, you can do it. I would be cautious.
Better to have a policy.
All right, why don't we hand it over to Jenny? Let her run her final poll here.
Excellent. Well, thank you both. Great content, tons of questions. Thanks to our audience for tuning in. But before we let you go, as David mentioned, I do have a final polling question for everyone. This is just a couple quick questions for you. We're looking to understand a little bit more about your life and LTD, and specifically what enhancements or kind of perks go along with those programs. So you'll see that those two questions pop up on your screen. Please take a moment and answer those for us if you can. And as you are doing that, I will remind you, we do record these sessions. My guess is a lot of you are going to want to review this recording and probably share it with your teammates. So please check in with your benefits advisor who invited you here today. They should have that recording early next week, and we'll be able to share that with you. And again, if we didn't get to your question today, we had so many questions. It was just not possible to get to all of them. Please connect with that benefits advisor who invited you here. They can further assist you and get your questions answered. And again, as a reminder, we do ask you polling questions during these sessions, and we really always appreciate your insights. We do publish the results of these polls in a couple of different ways. First is a market check survey. Those come out every month, about a week or so following the webinar. So you can, again, connect with that benefits advisor if you're interested in reviewing the results. We also publish quarterly infographics on a variety of topics. So when we ask you these questions, do know that we really value your responses, and it just helps provide a lot of information into what you and your peers are doing, and will hopefully help you as you continue to evolve your employee benefit strategies. So it looks like results are still coming in, so I'll leave this poll open for just a moment here. Looks like kind of a wide variety of responses. For the life, we're seeing a lot of will prep, grief counseling, financial counseling as some really common offerings. And on the LTD, we're seeing a lot of EAP, followed by direct deposits. But I will share those results out here in just a moment. All right, you should see those on your screen. So just as a reminder, again, please reach out to that benefits advisor to dig more into anything that we covered today, and they will also have a link to the recording of today's session. But that does conclude our time together. So thank you again to the Benefit Comply team. Thanks to those benefits advisors who are partners of AssureX Global for making today's webinar possible. And certainly thank you to our attendees for tuning in today. Have a great afternoon.